Okay, thank you everybody for joining. My name is Nick Blessing. I'm the secretary of the Kansas Green Party. And this is a presentation tonight about evictions in Kansas. We're going to be focusing on eviction law in Kansas to inform Kansas residents about what to expect and what their rights actually are if they or someone in their family or a friend or anybody they know ends up facing eviction or have other issues with their landlord. So I'm a public interest attorney. I practice various areas of law, including family law. I represent people in expunging criminal records. I do some simple probate stuff, but the vast majority of what I do is representing tenants in eviction court and advising tenants, when they have disputes with their landlords. This presentation is roughly going to focus on these items here, the timeline when somebody is facing an eviction, the different obstacles that are presented to tenants when it comes to being in court, and the way the law is set up, and just the way that the general practice is, the way that things happen in practice, rather. We're going to look at some procedural defenses, which are often things that can win a case for a tenant, but the big problem is tenants usually don't know that they have a defense. And then we'll also talk about some claims that tenants might have against their landlord, which when the tenant has an eviction lawsuit filed against them, they can then assert what's called a counterclaim. And a lot of time, well, I'll discuss that more later. And then we can just kind of have some general discussion, and we can take questions. If you have a question during the presentation, the main part of the presentation, just go ahead and put it in the chat, or you can hold on to it and we can bring it up at the end. We're gonna go. I'm not sure how long it will take me to get through the whole presentation, but I'm going to try to make sure we have plenty of time for just questions and general discussion. And we're going to have a hard cutoff of the presentation of the whole event at about 8:30. We might end a little bit late, a little bit earlier than that, but we'll see. So, compared to any other lawsuit, an eviction just moves really fast. Your other typical lawsuits, they might go on for several months or even years, going through the process of discovery and having several pretrial hearings, motion hearings, and then a final trial. But evictions, the whole eviction process probably takes about 1 month, and sometimes much faster than that. In a lot of the cases, they're for non-payment of rent, and all the landlord has to do is give a 3-day notice just to begin the case prior to filing the petition. And the petition is also known as a complaint. It's the document that's first filed, which has all the allegations on it. That's the reason why the plaintiff is saying that they are supposed to win and they should get the relief that they're requesting. Um, an answer hearing is required to happen in an eviction case, roughly 3 to 14 weeks after the tenant is served. Most likely, the tenant would be served by the sheriff or a court process server. And getting served just means that you get a copy of the petition and another document called a summons, which gives you that court date, that answer hearing date. And then trial is required to occur within 14 days after that answer hearing. So the maximum amount of time the whole process typically would take is just over 1 month, or about 1 month exactly. But a lot of times the trial is going to occur more less than 14 days after the answer hearing, and that first appearance is going to occur less than 14 days after the tenant is served. And there isn't really a lot of ways to slow the process down, unless there are a lot of cases where the case will just get settled because the tenant, especially lately, there's been a lot of rental assistance available. That's changing. There's going to be a lot less rental assistance available very soon. But there's a law, there's a Kansas law which says that the tenant has to put up a bond in order to get a continuance. And it's not super clear how much that bond is going to be. The logical thinking would be that it would be something equal to 1 month's rent or several months' rent or something like that. But essentially, the judge decides what the bond would be. And this also has other implications, because there are in a lawsuit, there are deadlines for discovery, which are actually longer than the time that it would take to go through a whole eviction case. Requests for production of documents, if the tenant wanted to serve discovery on the landlord requesting certain documents, then the landlord essentially wouldn't even have to respond to it, because the amount of time that's allowed for that is more than the amount of time there is in the actual eviction case. So this presents a real problem for tenants, especially when you combine that with the fact that tenants are not typically represented by attorneys. I don't have the exact statistics, but it's something like 90% of landlords are represented by attorneys, and so more like 2% of tenants are represented by attorneys. It's very rare for tenants to be represented by attorneys. There's also, I mean, in practice, there's a bias that the courts often have in favor of landlords. If the situation is that the landlord is going to be saying one thing and the tenant is going to say another thing, the court is most likely just going to believe the landlord, which is why it's so important for tenants to have documentation of all their communications they've had with landlords, because then they have something that they can point to. They have some actual evidence. But a lot of times that's not the case. People really often they operate very informally with their landlords. A lot of their communication is verbal, either in person or on the phone. I've got here on here financial issues. I mean, that's clearly why tenants don't have attorneys. We have a system in this country where you don't have an attorney unless you can pay for one. That's changing in some ways. There is in Kansas City, Missouri now, they do have right of counsel for tenants. That's in Missouri though. That's not in Kansas. It's not in Kansas City, Kansas, or anywhere else in Kansas. There has been some talk of them starting doing that in Douglas County. But I haven't heard any updates on that. I don't know if that's going to be happening. But there's a situation that we have where you have these eviction lawsuits, and one side is almost always represented, and the other side is almost never represented. And there are statutes, there are laws in place that are meant to protect tenants, but a lot of times they don't even get used. There are several statutes that are pretty tenant friendly, but there's not a lot of precedence for their use because tenants just so rarely have attorneys. And the judges who oversee these cases, they're so used to seeing landlords who are represented and tenants that are unrepresented, and the tenants, they're not lawyers, they can't make a legal argument. A lot of times there are some very well-educated tenants who can, they could represent themselves if the issue is simple enough, at least. But there's just such a clear disadvantage, and I mean, and just because of that, they don't understand the eviction process. Let's see here. Well, I'll go back here. So going back more to what the timeline is, as I said earlier, the first hearing that happens in an eviction case is the answer hearing. And the purpose of that is really to kind of just weed out cases. It's super important that a tenant shows up to that answer hearing, because if they don't show up, they will just get a default judgment entered against them. If they've been served that summons, which gives them the date and time of their answer hearing, if they don't show up, they will get a default judgment. And that's a default judgment is just essentially it's a judgment against you. The plaintiff, the landlord, automatically wins because the defendant tenant did not show up to defend themselves in this case. Those can be overturned, and that's a big part of my practice is setting aside default judgments. But that's kind of another issue. But even if they do show up, sometimes what happens is, they show up to the answer hearing and they don't know what to expect or what to do. And going into it blind is really bad for them, because the process is actually very simple. When you go to an answer hearing, all you're supposed to do is wait for your name to be called, and then the judge will ask if you admit or deny the allegations against you. And what you should do is just deny and ask for a trial date to be set. But I've seen it where tenants have just gone to that answer hearing and just said, well, we do owe the rent, so I guess we have to admit. And it's like, but no, they might have had some kind of procedural defense. They might have been able to assert a counterclaim against the landlord, and when they just admit, they just get a judgment entered against them. So that's another issue for tenants, not understanding how the process works, not having legal representation. About procedural defenses, the quintessential procedural defense in an eviction case is based on the notice that the tenant received from the landlord prior to the eviction case being filed. So there are essentially three types of written notice that a tenant might get that in order to start the eviction case. Excuse me. If it's a non-payment of rent case, as I said earlier, the landlord's required to give a 3-day notice, which it has to be a written notice. It's usually handed directly to the tenant, or it's posted on the tenant's door, and it has to say, you're in default in rent by this amount. You have 3 days to either pay or leave. And if you don't, then it's the landlord's intention that the rental agreement will be terminated, and then the landlord will be able to file an eviction case against them. If it's not for non-payment of rent, then the landlord can give the tenant what's called a 1430-day notice. Now, this would be used if the tenant has breached the lease or arguably breached the lease some other way. A big thing that you see sometimes is, especially in housing authority projects, you'll see, I've seen it multiple times, that a tenant might have a family member who has been banned from the property. And if they then invite them back, that would be breaching the lease. Also, I mean, damaging property and then not paying for it would be a reason to give a 1430-day notice. Having a pet when you are not allowed to have a pet. Now there's a whole separate issue with like service animals and emotional support animals. I'm not talking about that right now, but if you have a pet and it's not a service animal or an emotional support animal, and the lease says you're not allowed to have pets, then that would be a reason to give a 1430-day notice. Now, a 1430-day notice is essentially saying, here's how you breach the lease. You've got 14 days to fix it. And if you don't fix it in 14 days, then in 30 days, the rental agreement will terminate and you will have to leave. And then this last one only applies if the tenant is a month-to-month tenant, which is surprisingly common. There's a lot of people, usually when they rent, they just have a year lease. They don't do this whole month-to-month thing, which if you haven't done that before, a month-to-month lease is when it's like each month is its own lease, but they automatically renew. But either the landlord or the tenant can terminate the month-to-month tenancy for no reason at all. All they have to do is give a written notice that on the next rent paying date, which is at least 30 days away, the tenancy will terminate. And if a landlord gives one of these notices to a tenant and then the time period expires, the landlord can then file an eviction case. But so I've got more about the 3-day notice here. But sometimes, maybe the landlord didn't give the notice, didn't give any kind of written notice, or maybe there was some kind of error with the notice. There's some specific language in the statute, and it's kind of a Weasley argument, but it does work sometimes, that if the 3-day notice didn't say that the tenancy will terminate, then that might make the notice defective. More common would be, well, let's see here. Oh yeah. So the 3-day notice is really important because there's actually 2 required 3-day notices, as I've gotten on this last slide here. There's 2 different statutes. One is the notice to terminate the tenancy, and the other is a required 3-day notice to give the court subject matter jurisdiction. These statutes don't really matter too much for the purposes of, you don't need to know these statutes, but essentially those two notices are combined into one in practice. There's some Kansas case law which says that the 3-day notice does have to strictly follow the statute, otherwise the court doesn't have subject matter jurisdiction. And it's all kind of like legal mumbo jumbo, but essentially the idea is that evictions aren't a thing from the common law. Evictions are entirely created by statute. And when you have a lawsuit which is entirely created by statute, you have to strictly follow the statute. Otherwise the court doesn't have subject matter jurisdiction. That's why it's so important. This is more about the 14 30-day notice. A 14 30-day notice could be defective just because a lot of times, I've seen it multiple times actually, because they counted the days wrong. The landlord might have accidentally written down, the date that they wrote down actually only gave the tenant 28 or 29 days. Or something that might happen is there might be no evidence that the landlord, there might be no evidence that the issue was not cured during the 14-day period, in which case the court would not be able to hear the case based on that 14 30-day notice. So this text here is pretty much essentially what I described earlier about the 14 30-day notice. And once again, the 30-day notice, it can be a month-to-month tenancy. It can be terminated with no reason at all, which is why I really don't advise people to be in a month-to-month tenancy, especially if you want to be stable and stay in the same place for a long period of time. And then here at this paragraph at the bottom here, this is often what the issue is with with the 30-day notice to end a month-to-month tenancy. Because landlords mess this up a lot of times by, they'll put the date at the end of the month. Because it's kind of funny when you think about it. If I'm going to terminate your tenancy effective at November is going to be your last month, right? Because it's October 12th right now. So if somebody wanted to give you a 30-day notice right now, they couldn't end it at the end of October or the beginning of November. But it might make sense just thinking about it intuitively that like, oh, well, November 30th is the day that you have to be out. But that's not right. You have to, it usually the first of the month is the day that rent is due. Sometimes it's different. Sometimes it's like the third or the fourth or the fifth. Most cases it's the first day of the month. Sometimes it's just a straight up, the landlord will just give a straight up 30-day notice and they don't even pay attention to the rent paying period. And that's defective. If they don't end it on a rent paying date, then it's not a good notice and the case should be dismissed based on that. Okay. So now we'll get to the counterclaims. So for this happens a lot, that almost any eviction case that I get, there's probably some kind of repair issues with the apartment or house. I have it written down here as habitability issues, but more specifically, things like an appliance is not operating correctly, if there's no air conditioning, if there's no heat, if there's something wrong with the plumbing, or maybe a window is broken or is not airtight. These are the kind of things that usually it's probably a local housing code violation, and that's or it's some other issue that under the statute is a violation of the landlord's duties to the tenant. The landlord has to maintain the premises in compliance with housing codes that relate to health and safety, and they have to keep in good and safe working order all appliances, including like air conditioning, oven, refrigerator, that kind of stuff. And so if that's the case, then the tenant should absolutely counterclaim for that. And usually what I do to calculate the damages is I take a percentage of the rent for each month that the issue has been ongoing. Another one that I've got here is enforcing prohibited lease terms. There's another statute in the Kansas Residential Landlord Tenant Act, which essentially it says there are certain things that you can't put in a rental agreement. You can't put in a rental agreement that the tenant pays the landlord's attorney fees if there's a legal dispute. That's unenforceable. You cannot have any terms in the lease which require the tenant to waive any of their rights or remedies under the Residential Landlord Tenant Act. So for instance, if repair issues that would be the landlord's responsibility, if the rental agreement says it's the tenant's responsibility, that's unenforceable. And if the landlord knows that the provision is unenforceable, and they attempt to enforce it anyways, the tenant has a claim against the landlord for that, for any actual damages that the tenant incurs. Another one is if the landlord, there's a couple of different ways of describing it, but reduces services, diminishes services in retaliation to the tenant. Like, so the ultimate the ultimate decrease of services is an eviction. So for instance, if a tenant were to call code enforcement on the landlord, and then the landlord initiated an eviction after that, that's potentially a good claim for retaliation. The problem with it is that it's hard to prove the landlord's intent. I've not seen a tenant get win on this issue. But my thinking is that you have to look at you have to look at the temporal relationship between the events. Was it right after the landlord received a letter from code enforcement that the landlord initiated an eviction action? If you can prove that, that'd probably be pretty good evidence. If you got it in writing, if the landlord said something in writing to the tenant that, oh, now you called code enforcement, now I'm evicting you, that would be really good. But that's probably never going to happen unless you have the stupidest landlord that I've ever heard of. Another potential counterclaim is unlawful entry. Landlords are required to give reasonable notice before entering the premises, unless it's like an emergency, like a water leak, like flooding or a really bad water leak, or some other kind of emergency. In that case, I believe the tenant is entitled to any actual damages. Some of these, and I might look it up later, so some of these have better provisions for the tenant. If the tenant were to win on a claim for diminished services, if the landlord willfully diminishes services, and that'd probably be something like the landlord disconnects the electricity, like on purpose, just to mess with the tenant, or the gas or the water or whatever. That would be, if they willfully did it, then the tenant would be entitled to 1.5 times 1 month's rent, or 1.5 times their damages, whatever is greater. But now with all of these, now I'm going back to the way that the law is carried out in practice. Let me make sure I don't have another. This is my last slide. The way the law is carried out in practice is that, well, the tenant, the tenant is not going to have an attorney. The tenant doesn't have the resources to, in most cases, file their own independent lawsuit against the landlord. But the landlord can always file an eviction case against a tenant. So what we have in practice is these counterclaims, these potential claims that a tenant can make against a landlord. They just never happen. It's so rare for that to ever be done. And so, I mean, we've got a lot of law, we've got a lot of cases where, there's an eviction case, but these statutes that give some relief to the tenants, there's not as much of a standard for the courts to go by, because it's never litigated. So, I mean, this is a reason why, in my opinion, we need right of counsel for tenants. Tenants need to have the right to an attorney. Because my question is, if you're not represented, do you actually have any rights? Because the way it looks in practice is it appears that you do not. There, in a lot of these courts where, as I've said over and over, I feel like that the tenants are never represented or almost never represented. There is so little due process for tenants in these eviction cases. And it results in an unequal application of the law. But I don't think right of counsel on its own is enough. I think that we need to have executive enforcement of the requirements for landlords to maintain the properties that they're renting. Because there are so many places where it's just a slum, and the tenants who end up living in them, they live there because they have nowhere else they can go. The rent is too high in other places. Most private landlords require that you make 3 times your rent in order to be approved there. And there's so many people who are on a fixed income from SSI or SSDI, and they're not making 3 times $800. But they can be approved by a slumlord. Absolutely. Anyways, I'll stop there. If we want to open up to discussion now, we can. Does anybody have any questions or any comments, observations?
I have a question quick. Forgive me if I missed something that you've already said, but so say somebody is like wrongfully evicted. Is the purpose of like these trials kind of being so quick for these kinds of problems, is that so that way they could continue to live in the house, or what is the goal there? That if happens that it's like a quick, only a month turnaround.
Well, if somebody's wrongfully evicted, well, what do you mean by wrongfully evicted?
So like, I guess, how should I put it? Like, say they get like one of those 1430 notices or something like that. Mm-hmm. And they want to try to continue to live in the house. Is like the intent that they could continue to live in the house, like after the fact, or
after the eviction case?
Yes. Is that ever like what happens? Do people ever go back to that landlord or whatever? Or?
I don't know. I mean, I don't think so. It might happen sometimes.
So
go ahead.
Yeah, I was just gonna ask. So is it really more about paying damages? Like,
well, it It depends. Well, that's a good question because it's different landlords want different things. And
Okay.
sometimes it's based on who the tenant is. Sometimes it
Okay.
seems like they just want the money and they'll be willing to dismiss an eviction case as long as they get paid. Or sometimes they just want the apartment back and they don't care about the money.
Okay.
But and I guess, you know, on that note, I guess I didn't describe the whole process, I guess, because I kind of stopped at like there's an answer hearing and then there'll be a trial. If the tenant loses, whether it's after losing the trial or they get a default judgment or they admit at the answer hearing and get a judgment that way, there's a separate order which is called a writ of restitution that gets filed and gets issued by the court to the sheriff, and the sheriff will come and remove the tenant. Like that's like the actual eviction. Everything else that
Okay.
I kind of talked about here is everything that leads up to that or everything that tries to stop that. But that's the ultimate thing, is it's physical removal from your home. I mean, it's actually very, but I mean, you were saying something also about like what the purpose is for why it's so short.
Yes, I wasn't sure if that was intentional or if that was just kind of how things happen to work out.
Well, I think it's so short because of the way that we look at private property in our society and in our system of laws. Private property is like this like that you own, like the landowner's rights are like so sacred under the in our society and in our system of laws. The way I look at it is it's so quick, and you know the tenant has to pay a bond in order to get a continuance, because essentially the state laws operate as free insurance for the landlord. You know,
Okay.
we want to make sure the landlord gets their property back as soon as fucking possible.
Okay.
That's my read on it, at least.
Okay. And so, okay, so that makes more sense to me now. It's kind of more to the benefit of the landowner as opposed to the benefit of the tenant. Okay.
Yeah.
So typically with these kinds of things, what is, I guess, the goal of the tenant then? Is that to not have to pay like a particular charge or fee or something? Or are they just trying to like, you know, receive like payment for damages for being kicked out kind of too early? Or is it something like, or are they just trying to find a place to live? And so part of the goal is to like remedial housing in a sense, even if it means still staying in that plot of land for until like X amount of time.
The goal of just defending the eviction case or bringing a counterclaim, like which are you asking?
I'm
They're
sorry.
kind
So
of
I'm like,
both. They're kind of connected.
Yeah, I was assuming it was connected, but so
I think so.
I apologize because I don't have the vocabulary for this because I don't really have much of a background in law.
Yeah, and that's I have a lot of trouble with that because I'm steeped in it. I'm steeped in the vocabulary. So yeah, I know I probably use a lot of terms that are like not normal terms, and it's just it's hard for me to put some things into layman terms.
Yeah, I mean that's just like some jargon words like exist for a reason because there's no dumbed down equivalent of them without like explaining it in like a paragraph. So, you're doing the best you can.
But what you're asking is, what's the tenant's goal?
Yes, like
I mean, the tenant's goal is to either not be homeless or just not have a judgment against your record, because you do not want an eviction
okay,
judgment on your record.
okay, and that's basically
If
what I
you
was trying to get at. Although I didn't think
yeah
about the record thing. I didn't realize that was a concern. It's not something I've experienced myself before, but that totally makes
yeah
sense.
well it ruins well and it's another aspect of the problem that we have in this country and the system of laws that we have is because we punish people for being evicted. And
Mhm.
there's a lot of problems. Like, I didn't really talk much about Section 8 and HUD housing, but having an eviction on your record can completely close those off as options to you.
Oh wow.
So the people who need housing the most are the people who are getting evictions on their record. But those are the people that our system chooses to exclude.
Okay.
But it also just hurts your credit. I mean, having a judgment on your record, that shows up on your credit report.
Okay.
And so you can't get a loan, you can't get a credit card, which there's a lot of things that there's a lot of doors that are closed for you, including just getting another apartment somewhere else. Because landlords do rental history checks, and depending on what county you're in, well, there's some way that they can just look up court cases online, and they can find your court case. So I mean, unfortunately, sometimes being homeless with no well. In a lot of loser eviction cases where it's just like, that the tenant is going to lose one way or another, they're going to lose. It's better, honestly, it's better if they just end up being homeless without an eviction on their record than being homeless with an eviction on their record. And I mean, that's fucked up.
Yeah, that is crazy. Thank you for explaining all that though, because now I like understand the
Yeah.
background of it more.
That's important context too, for all of this. And I haven't had time to kind of look into and study what, all the ways that this affects people. But I mean, I have seen it in my work. But yeah, I mean, simply put, having evictions on your record is going to make it so much more difficult to find housing in the future.
All right. Well, so thank you for explaining all of that. That answers my question a lot better. I know I didn't explain the question that I was getting at really all that well, but you definitely were able to give me a pretty thorough like follow up with it. So thank you.
Yeah, no problem. Thanks for your question. Any other questions or just comments, or we can just kind of have more general discussion if you guys want.
So I do have another question if it's not going to
Okay.
like.
Yeah, go for it.
So I'm curious, is squatters' rights or anything ever something that like comes up anymore in
I'm sorry. Go ahead.
Okay. I mean, I don't know, because we were just my fiance and I were actually just talking about it, like unrelated to this. like, I don't know if like squatters' rights is really like an actual thing that exists anymore, or if it exists in the state of Kansas or not. So it's just figured I'd ask about that.
It's not a thing.
Okay.
It's so see, I don't see actually I'm not really sure where people came up with squatters' rights. Maybe there is some origin to that. There is something else that I guess the thing that is the closest thing to squatters' rights that I know of is something that rarely comes up in real life. It's called adverse possession. And I don't remember all the elements of it off the top of my head, but adverse possession is essentially like if you are not the record landowner, but you've been like living there, not with anybody's permission, and you've just been like very obviously and openly like been the person who is like using this land for whatever its regular purpose is, and you do it for whatever the required period of time is for that state, then you can then become the owner of the property. But it very rarely happens because, well, for one reason, the time period is very long. In Kansas, it's 15 years.
Okay.
So no, there's not really squatters' rights, other than I guess. I mean,
it kind of
sorry,
sounds
go
to
ahead.
me like the adverse possession is kind of like the more technical term for it. And I knew there
Yeah,
would
maybe.
definitely be like caveats to it in a sense that's more than just like, you can't just live at a place for a while and then say it's yours. I figured
Yeah.
it would be long. I looked it up, and I think adverse possession is like 21 years in Pennsylvania and like 10 years in New York. So I was surprised that
Yeah.
Kansas is actually a bit more lenient than Pennsylvania is with it.
Yeah. I mean, 15 years is still a long time for somebody
Yeah.
else who actually owns the property to like not do anything about it.
Yeah.
When somebody else is just like occupying and using their land, that's a long time. I mean,
Yeah.
I think 21 is crazy, but
Yeah. 2020. Yeah.
I mean, other than that, I mean, typically I don't know if this is what squatters' rights is supposed to mean, but you're if you're living in a place and somebody wants to kick you out of there, you now informal evictions do happen, like where people just get kicked out and there's no court involvement at all. That does happen. But you're supposed to have due process. At least the bare minimum, the process that I've described tonight is supposed to happen. So, I mean, maybe that's squatters' rights, but I'm not sure.
All right. Thank you for explaining that, because like I said, I don't know. I don't have a lot of background about the law, and so I figured that something like squatters' rights might be a little bit steeped in myth as opposed to reality. But that I was just curious. So thank you.
No, I mean, thanks for asking. I mean, because it's not the first time I've been asked about squatters' rights. I mean, but yeah, I couldn't help but smile when you asked it. But yeah, it's not really a thing. Hmm. Anyone else?
We don't have any
No, no.
statistics, right, for how many evictions happen.
What?
Do we have any, like, do you know how many evictions happen per month?
I don't have the statistics. It
Yeah.
definitely varies a lot by county and region. I think there's definitely a lot more. Well, Wichita has a lot of evictions compared to the rest of the state. But I don't have the numbers. Sorry.
I was curious.
There was this judicial committee on evictions. They put some report out. I think I didn't look at it too closely, but they did have some numbers. I wonder if
Well, like Johnson County is probably not that high.
Johnson County is high.
Is it high?
Johnson County is a high population. So
Yeah.
there's a lot of evictions in Johnson County. Johnson County is better in a lot of ways. I think that like problem properties that have like really bad like habitability issues, it's not as big of an issue in Johnson County, but the rent is also higher. There are a lot of places in Johnson County that, it's over $1,000 for a 1-bedroom.
And we're paying over 2,000 for our place. Combined with everybody.
Right, but you've got like a house, right?
Yeah, I got our house. Yeah.
How
It's a
many
lot of money,
bedrooms?
3.
3.
Yeah, 2 baths.
Yeah.
So, sorry to interject, but that's like so expensive compared to Wichita.
Yeah, Wichita, the rent is actually pretty cheap, isn't it?
Yeah, super cheap. I'm paying like Winter and I are paying like 800 something a month, and we have a 2-bedroom house.
That's pretty nice.
Yeah.
My Kansas City studio is $840.
Oof.
Damn.
Yeah. Ad hoc committee on best practices for eviction proceedings. I have the report here.
Are there ways for people like a tenant to get an attorney if they don't have one? Or I know they're like
contact legal aid. Look up Kansas legal aid.
that's why I do it.
There's qualifying for that depends on your income though. If you're over income, you won't qualify for their services. But I mean, there's very few private attorneys that, even do eviction defense because, there's no money in it. It does happen occasionally though, but it probably happens like for tenants who like know somebody, like there's a lawyer that they know.
Yeah.
Yeah.
Interesting. part of the problem is they don't make enough money if they're a tenant, because they're a tenant, but.
Well, it's not because they're a tenant.
I think.
I mean, because there's lots of tenants who, don't have issues with this because they make enough money.
Yeah.
It's because, it's disproportionately, it's people who are on a fixed income, especially seniors who are on SSDI or, on retirement, Social Security.
Yeah.
Or people with disabilities who are on SSDI or SSI. And yeah, they're on a fixed income and they don't, they don't make enough money to make the rent. Or, or people that were making plenty of money and then they lose their job for one reason or another. Or, if we look at things more holistically, like, what if you have like a freak accident or something and you end up having to pay a bunch of hospital bills or, some kind of like unexpected expense that then eats into your the money that you normally would pay for rent. Hi Natalie, thanks for joining. We're kind of toward the end now. I finished the main presentation, but if you've got any questions about evictions, you can go ahead and ask, and we can chat for the next 15 minutes. No other questions?
What can we do to stop evictions?
Well, we need to change the law.
Yeah.
Stopping evictions, that's a big question. And it's not necessarily that evictions should just totally not be a thing anymore. There are times where somebody needs to be removed from a property. I'm talking about like more extreme circumstances. But we have to kind of push against this way that we view ownership of land, that should housing be used as a way to make profit, or should housing be a human right?
Yeah, right.
Why aren't we investing in affordable housing or just investing more in public housing and the programs that we have, the federal programs that we have, housing choice vouchers, and project-based Section 8 assistance from the Department of Housing and Urban Development. Those programs are so underfunded. There are so many people who would be eligible for housing assistance, but they don't receive any because to get it, how hard it is to get a housing choice voucher? It's like impossible, basically. It's a huge list that's often, frozen for months or years, and nobody else can get on the waiting list. I mean, there's just been no investment or any willingness, by the people who are in charge to fix this problem. It's been a problem for decades.
As long as you have capitalism, you're gonna have to. It's gonna be the same problem.
Right. It is a problem that is rooted in capitalism. I definitely agree with that.
Yeah, which people don't want to. They love it. At least there's no sign people want to change. I mean, have to get people to change. But are those programs, are they like frozen because they just run out of money? Is why they freeze it?
There's only so many that they give out. Yeah, they only have so much funding. I mean, the other thing is about housing choice vouchers. The way a housing choice voucher works is you apply with a public housing authority, which gets funding from the federal government. And if you get a voucher, you then have, I think it's like 90 days or maybe 120 days to find a private landlord who will accept the voucher. And then the idea is the tenant pays 30% of their income, whatever that is. And then the housing authority pays the remainder. But the problem is there's also, there's this, I forget what they call it, but there are like these guidelines on how much the rent should be for that area. And if the rent is higher than that, then the tenant, well, the tenant has to pay more. And a lot of, I'm not explaining this well. There's a lot of places where you're not going to find a place to rent that's where the rent is low enough where the tenant is actually paying only a third of their income. And the tenant ends up having to pay, I don't know, maybe $100 more than a third of their income. It's, there's so many factors here that altogether are just, I think it's just squeezing tenants, especially people that I've been talking about who are like on a fixed income.
So I have a kind of related question, because one thing you were mentioning is the need to change the law. And I do think that's obviously necessary. But I'm curious, are there also laws in place that are just not being enforced appropriately? Or is there also like maybe judicial things going on where it's like the law is being enforced, but it's like coming down to judges and courts that are just kind of, giving it over to the landlord?
Yeah, and I mean that's kind of what I've described a little bit earlier in this presentation. There are all these statutes that say that the landlord has to maintain the property, right? Or the landlord can't diminish services, but how often is there actually a judgment against the landlord for those things? How often does the tenant get granted injunctive relief from the court, essentially an order from the court ordering the landlord to fix the plumbing, That never happens. So yes, there's a lot of these things that I talk about as being potential counterclaims. Those are laws that are never enforced.
And so what would need to be like done to enforce them? Like, how do we check in on the systems to kind of make sure that, hey, this needs to actually be considered?
We need a lot of lawyers to represent tenants and bring the claims. We need to make case law. We need to get a case in front of the Kansas Court of Appeals or the Kansas Supreme Court, showing with the law being applied. It has to become. So I mean, the thing is, it's a regular practice for the court to just be like, okay, there was a 3-day notice. Okay, the landlord proved that the tenant didn't pay the rent. Okay, here's your judgment for immediate possession. That has been done over and over again. The courts understand that that's how that works. But the courts never look at these other statutes because they don't need to. They don't even need to know that they exist. But it's the same statute. It's a statute in the same act. It has the same force of law, or it's supposed to have the same force of law. And it's in this, it's just as valid as the statutes that, give the court authority to grant immediate possession when there's non-payment of rent. But it just doesn't come up because tenants don't know how to present those claims without having an attorney. I mean, I really think there should also be some kind of executive department that just enforces these. Or like maybe it should be a division in the attorney general's office or something. Like I really think that, the state executive branch should get involved here. But they don't, and there's not really a department that, deals with this.
Yeah, that was going to be what I was going to ask, was like, what state level entity would do that?
Currently none. I don't think that there's, because usually, I mean, with certain things, the attorney general can bring claims for certain things, like deceptive acts and practices under the Kansas Consumer Protection Act. But there isn't a provision like that in the Kansas Residential Landlord and Tenant Act that gives the attorney general the authority to do that. So I don't think the attorney general can do that. So that means there is no one in the state executive government that can, at least to my knowledge. I'm pretty sure I'm right about that.
Now, is that just do other states set a precedent of having some kind of entity that does that kind of thing?
I hope so. I don't know, actually. I haven't looked into it. Kansas is what I know. I know Kansas law. Kansas is the only state that I practice in.
Yeah. And I knew I was kind of like maybe asking like more than I could expect a person to know, but I just figured I'd like ask just in case.
I mean, I'd be interested to find out, but I haven't looked into it. Anybody got one last question or comment?
Is the Democratic or Republican Party gonna do anything about this?
Well,
is it-
they have not done anything about it. So I would say no. I think they're both, and actually, you know, this is a presentation by the Kansas Green Party, and one of our big things is that we are different from the Democrats and Republicans, and we actually want to help people, and we, whether it's about trying to prevent or lessen the effects of climate change or the climate crisis, or we want people to have health care without having to pay for it and being steeped in medical debt for the rest of their life. And we want people to have housing as a human right. But yeah, and we in the Kansas Green Party and the Green Party at large, and in third party politics in general, we talk a lot about how we have a political system which is what a lot of people call a duopoly, where the system that we have has produced two dominant political parties, and because these two political parties are so dominant, and they basically, anywhere you go in the country, one of the two parties is in control, and then the other party is the one that's the second biggest party. We have stagnation. We have a lot of issues that aren't being dealt with because it does not serve their interests to deal with them. The people that I'm worried about and the people that I try to help in my job are not people that it serves the Democrats or Republicans to make sure have housing, or aren't gonna get stuck with a money judgment from rent that they weren't able to pay or whatever. I don't know. It's a big question that you ask. I can, and we've been talking about Kansas eviction law here, and Kansas actually in some ways has better laws than a lot of other states. Some states it's much worse. Apparently in Arkansas, an eviction case is actually a criminal case.
Oh, wow.
And I don't even know what that looks like, but it doesn't sound good to me. That might be, I don't know. I haven't done a full survey of all the states, so I'm not, like I said, I know Kansas, but that might be the worst state. And that's a very Republican state, obviously. Arkansas is. But so it's hard for me to give an answer that encompasses the whole country. I guess Kansas City, Missouri is clearly Democrat controlled, and they were ultimately pressured to pass a right to counsel for tenants. So that's something, I guess. And Douglas County is in Lawrence, Kansas, is Democrat controlled, and they're apparently thinking about it. So there's something to be said there, I suppose. But this system that we have and all the problems that it produces is not something that's going to be fixed by one thing. It's going to take a whole lot more. And it is 8:31, so I'm going to close up shop. Thanks everybody for coming. I am going to post this on the Kansas Green Party YouTube page. So that will be able to, the whole presentation will be able to be viewed there. We'll most likely have a Facebook post and probably a Twitter post as well with the link. So if you want to rewatch it, or if you weren't able to see the whole thing, you can see it there. But with that, thanks everybody for thanks everybody for coming tonight. Have a good night, and I'll see you later. Bye.
Have a good one.
You too. Bye.